both Blue Media and Baby Blue Limited?
I think this is a business question, so
sure. So Baby Blue is doing very well. We're looking towards our future, and we think that there's great success down the road. We're not here today trying to sell off Baby Blue because we have any concerns with it, simply because we're pivoting as a company. We've seen that webvids is doing extraordinarily well. We believe that this trend will continue with people turning towards streaming media rather than watching live TV. And we believe that our current capacity as filmmakers will be able to succeed in the future by using our capacity at the moment to cater towards that audience rather than using towards Baby Blue.
I think ultimately we're seeing this as an opportunity for growth rather than to cut any ties we're concerned about. So we have, future plans to do with potential acquisitions or changing our business kind of focus at the moment. And so this is just a means for us to make sure that our priorities are in line. There's no concerns financially.
Thank you for providing that assurance. I think absolutely you need to adjust with the market, with where your business is going. I completely understand that.
I think off the back of that, we're just wondering why there seems to be a rush with receiving the funds.
Sure. So can you just clarify where you perceive that rush coming from?
I believe your counsel in the earlier stages requested clarity on whether it would be an upfront payment or a tiered payment scheme, and just wondering if there's a rush in terms of the upfront payment.
So perhaps I can clarify that from our part. The reason we offer a payment scheme isn't because we're in a rush for funds. We're just simply looking to cater towards your interests as well as ours. We pride ourselves on the way we look after our employees. Looking later down the line at different discussions, if offering you guys a payment plan will help us to protect our employees in a better way, then we're happy to do that. Okay. To go back before, I think we said about putting a ballpark figure out there, we're looking for £38 million for the sale of Baby Blue. Again, this is subject to the terms we come up, we agree to later on in this discussion, such as our employee benefits going forward. And that's kind of the figure we're looking at the moment. In terms of why we want that money, addressing your concern about finances, we're not in any financial trouble, at least I hope not as CEO. The reason is we want to invest quite heavily into webvids, creating new TV programs. I think there's some real opportunities in the market at the moment. So we're looking to raise those funds by sending Baby Blue off to a trusted second parent, if you like, to go and raise Baby Blue while we go and pursue other things.
I think maybe to summarise that, we obviously have this opportunity for growth, and obviously we're aware this market is, it can be quite competitive, and we've got some great ideas, and we want to make sure that we harness those at the prime time. At the same time, we want to make sure we have certainty, so we don't want to rush into those opportunities without certainty of what's going on with the rest of our business and Baby Blue. So we want to ensure that this process goes as smoothly as possible, so that we know that we're sending Baby Blue into trusted hands, but also that we can pursue our growth targets without any concerns about.
I think you can see we care about Baby Blue quite deeply together.
Absolutely, with the analogy of a parent.
Exactly. Can we ask what you'd be doing with Baby Blue in the future once acquiring it?
Absolutely. So I think, as I did briefly mention before, the key aspect for us here is the 3Bs news and the associated podcast. That is the primary focus, because obviously that is where the compatibility lies in terms of Baby Blue's media offerings and our ethos in terms of educational content that appeals to teenagers.
Perhaps off the back of that, could I add, obviously you've got quite a diverse range of products already, and we know exactly what you're trying to tailor to, but how will Baby Blue kind of fit within your wider conglomerate in terms of, is it something you're willing to invest a lot of time into, or that you're kind of, it's there to fill a gap, but it's not your priority?
At this point in time, it certainly is a priority. We've identified that there's a gap, and when we find gaps, we want to fill it. So we want to put in the resources that's required to do so. And I suppose at a high level, we would want to assure you that we very much appreciate the people and the team within Baby Blue. I mean, if you look at 3B's media, for example, that's entirely built off the back of 3 individuals. We would not be coming today if we did not care about those individuals, for instance. So please do take that assurance that we would be wanting to see what exactly you're looking for in terms of making sure that they're looked after and seeing how we can accommodate that within our structures.
My client's platform produces high quality award-winning productions, and that's the level of quality we expect, and we wouldn't be here today if we didn't anticipate that this would be the same thing of the same caliber. Obviously, what that would look like in the future is a process of development. Obviously, my next question for you was what the Taylor sisters actually anticipate if they had any intention of staying with Baby Blue, and what they'd like to do in the future, if anything beyond the news and the podcast.
I think if I can speak on that, they're obviously very, interested in making sure that what they've worked on for so long reaches the audiences, and kind of gets the respect and the recognition that it deserves. So they certainly don't have any intention of leaving. However, of course, that comes with a strict loyalty to what they've built. And so one of our primary concern, and one of the things we wanted to address within our particulars of the acquisition, was that in acquiring the company, you wouldn't make any changes to the current kind of situation that they've developed. Their comedy show in particular is kind of included within that.
Can you expand on the comedy show? Because to our understanding, that is a separate aspect to the 3B's news and podcasts, which are our primary interests at this stage.
Sure. So, as you know, the 3Bs also have a fantastic comedy show called Canteen Chips and Dented Lockers. They're very keen to keep this going. And while they're open to a new future and they're excited getting to work with the people who produce documentaries like Secret Oceans, they're looking forward to that new adventure. They're very much keen on holding on to that comedy series as well. And I think, that comes from, we've seen these guys come up from YouTube to being employees at our company. All we want to do is nurture them and see them grow. We see real potential in their talent, not just at what they're achieving now, but also in the future, in their way they're able to connect with teenage audiences. We think it's just unparalleled. So we really believe in them when they say, we want to keep this comedy series going, because if they see potential there, we trust them in that. And that's something that they've asked us to communicate to you guys today in our discussion.
And again, you spoke about kind of viewing this transaction, this acquisition in a holistic manner, and that's obviously the way we view our individuals and our employees within that. So they are very educational, but they're also very entertaining, and this comedy program comes within them as individuals. And so that is one of the first kind of key points that we have to, emphasize, is that with the 3Bs will most likely have to come
with the comedy show. I think absolutely, as I did mention before, we do not believe entertainment and education are mutually exclusive. And if there's a way for us to learn more, potentially at a subsequent meeting, about what exactly is involved in the comedy show, and seeing whether that can engage in some rearrangement, perhaps some reimagination, so that it does have an educational lens, because at the end of the day, that is what we're here for. And we completely take your point that these individuals are looking for growth opportunities in a diverse manner. I think it's important to note that our Burgundy News is the largest watched news outlet in the entirety of the UKA. And with that in mind, it would expose the Taylor sisters to a wealth of growth in that aspect, and a brilliant platform to learn from skilled professionals and be exposed to the markets that we operate in.
I think on that point, we do echo that sentiment and make sure that that is known. We were just wondering, has Blue Entertainment been in talks with any other media companies or anyone else for the sale of Baby Blue?
We have not so far. We're looking at lots of different options, obviously, as a company, looking forward to our new productions, not only about the sale of Baby Blue, but also towards strategic partnerships, towards the upcoming series that we want to produce. In terms of Baby Blue, this is our first discussion about it. And I think that really represents the level of respect we have for your company. We wouldn't want to pass Baby Blue on to anyone that we couldn't trust. We really see a lot of potential there, and Baby Blue is succeeding as it is. So if we keep Baby Blue in the end, then we're very happy to, but we see that Baby Blue can go from success to success and probably grow even further under your management, where we look to pivot to different areas, which is why we're sat at the negotiation table with you both today.
I think maybe just to, circle back to your question about the 3Bs, I think it just needs to be emphasised that I appreciate the fact that you have your own kind of plans for the business, but we don't have the three of them here today to speak for themselves. But from our conversations with them, it's very crucial to their decision whether they would join your company as to whether that program is taken alongside them. So that is quite a tough line that we'd have to draw. Obviously there'll be open discussions about where that fits in, but they would be very reluctant to change or remove it entirely.
I don't think that we would absolutely suggest to remove it entirely. It would be that looking at where it aligns with the ethos and working collaboratively in a way that ensures that they can pursue their aspirations and ultimately appeal to our overall ethos. So I think that we have reached a consensus in that aspect. We can obviously revert back and speak to them directly and speak to our creative directors at a subsequent meeting to see how that might all play out.
So in just writing this down for our own kind of clarification, when we come back at the end, we can kind of draw a line under the fact that the program and the freebies is quite secure. Obviously, with further conversations, I'll come back to this.
Further conversations and looking to align it with our ethos
Yes.
and educational lens.
But there's no current view from you
To
make any
exclude it
significant changes.
entirely. No significant changes provided it does align with the educational ethos. Again, we don't know the precise content of this
course.
comedy show.
We don't want to speak on behalf of
Precisely.
Betsy and Barbara.
So it
either.
is in broad terms at this stage.
As long as we can reassure them that option is there for them.
Thank
Of
you.
course. I think on that point, it might be best to move to the first agenda point being the current copyright claim. Seeing as though we put that down on the agenda, I'm happy to lead on this point.
Please.
We do understand that Baby Blue is likely to face a copyright infringement relating to the alleged stealing of video content and formatting of their videos. Would you mind speaking a little bit further as to what those allegations look like and which media outputs they relate exactly to?
Sure. As we said at the start, this discussion today, we believe should be built on trust and honesty. So we'll tell you full details about the allegations.
Thank you.
The allegations are alleged by two popular YouTubers, Teresa and Tim. They allege that we plagiarized their video content. I can say hand on heart that we absolutely did not plagiarize any of their content, and we are steadfast in that belief. So we do not believe they have any case to go to trial.
I think speaking from a legal standpoint, we'd like to emphasize again that this is just a mere claim they've brought on YouTube, on their channel. It's not been, they've mentioned legal action, it's been thrown around, but that's so far it stands on YouTube. And we know, having worked in the entertainment business, how changeable these things can be. Again, we reiterate that our business is entirely honest, and we wouldn't be trying to sell you a business that's not entirely open and our own creative products. So they have had a claim that's been brought at £2 million, but we're quite keen that figure wouldn't ever be reached because there's nothing's been brought in the court as it is. And if it was, then we're quite confident that there's nothing.
I'll be honest as well. Yeah, it's me being stubborn. Someone's alleging about my company that I built with my wife for a long time, that we cheated the system, that we don't deserve what we've gotten. So I'm quite reluctant to pay that. But of course, I take a holistic view of my company. If I see that it does benefit my company to pay off a settlement, 2 million is a number they've thrown out on YouTube. I'm sure we could get that down as well. Then I would consider signing a settlement agreement with them that did not admit any liability, just for the benefit of my company moving forward.
That would be obviously with the view that this acquisition would go ahead.
I think there's also the point to note that if any of the claims were brought against any of the three sisters in terms of their news or their podcast production or in terms of the cartoon, there's a consideration for us to have from a legal standpoint as to whether we can actually continue the current production of the shows if there is a real legal issue that has arisen. Would you mind speaking to the specifics of what the claim actually looks like if you have that information?
Potentially with which media offerings in particular it was related to.
Sure, so we actually don't have that information, but I appreciate why you'd want to ask. Again, to be completely open and transparent, what we have got is that they've alleged on YouTube that Baby Blue has plagiarized their video content over the years. So it sounds like the allegations span a range of different items on our content spreadsheet. But again, we can absolutely say that this is not true. And there is no legal risk in terms of this. And actually, in a slightly twisted way for me, if it did go to court, then I feel like my company would be vindicated to be able to firmly say, no, this is not what my company has done.
I think we can kind of reassure you that they're very broad claims, and I think that speaks for how little actual foundations they have. There's a lot of competition in the market, and I'm sure it's just reactive. We understand completely that you'll have some concerns, especially on any legal ramifications in the future. But we just don't have the information to give you any specifics.
We do thank you for those assurances and for your very heartfelt communication of the way that you're willing to protect your company into the future as well as at the moment. I think there are two issues which really stem from that. The first being, regardless of whether there is substance to these claims, YouTube is a creature of the people and does gain momentum and has in many events caused severe reputational harm to companies, even if there isn't necessarily that material cause that is shaping those claims. So we'd be interested to see how, on a reputational side of things, we're seeking to mitigate this. And then in addition to that, looking to how in the future, in combining forces, a sort of, I think my counsel can explain this best, in the event that there was any liability involved, how you would respond to that.
I mean, I can address the reputational point before we maybe go on to the second question, just to keep on track. Obviously, you mentioned that YouTube is, and entertainment in general is a result of the people. And we think that's probably why it's actually more important that we defend our own business. If we just settle immediately, that's, as our client has suggested, is in a way admitting guilt that we feel we don't actually have. So I think if it came to it, it'd be more important that we defend the honesty of our company to make sure that reputational damage is mitigated as much as possible. People don't have any skewed views on whether we are an honest company or not. But of course, we're willing to partner. We want to send our child to you. So if a settlement would ease your minds more, we are open to doing that.
I think it's more so an indemnification of Red Media in the instance that there were any legal settlement or legal proceedings to happen. We feel as though because this preceded Red Media, it would be in the best interest that it wouldn't preclude us. It would preclude us from any agreement that would take place.
I think in noting your confidence that there is no base to this claim, an indemnification should not really cause detriment to either side here, but it would provide that added layer of security for us in moving forward here. So,
sorry, I didn't mean to interrupt you.
No, so that is essentially our position, and we would be interested to see if that's something you'd be willing to accommodate.
Yeah, of course, we feel the same way. If we don't believe there's any risk, then there is certainly no harm in indemnification. I think our main concern was whether you'd want us to settle or whether you're happy for us to handle the.
Can we clarify on that point what you want the indemnification to be against, just in certain terms?
I think just in terms of if any litigation were to arise or any claim from the future were to arise, should the settlement agreement not be sufficient, in that they didn't have, it allowed them the capacity to bring the claim again against specifically the three sisters that we would hold responsibility for under Blue Media, it would indemnify us from that, and it would bring you back into the equation if the way that in which you settle isn't sufficient enough, or the way in which a litigation is handled isn't sufficient enough.
Could we, just to clarify, this is limited specifically to Teresa and Tim litigation ongoing at the moment, not any, future, if anything, we don't want to be too broad so that any potential litigation ends up being brought back onto us when you have control of the company.
I think it started specifically with this piece of litigation, but if there's any more claims that arise from the time in which you were in control of this entity, it would make sense that it would come back to you, seeing as though we had no sway in what was happening, we had no control in what was happening, and we had no knowledge to that at this exact point in time.
Well, look, I think in the interest of time, because there's a lot to get through today, and also because I believe in my company, I know what we've produced, and I know that these claims are baseless. We can agree to an indemnity today. And I think we can move forward on that basis, that anything stemming from Teresa and Tim, any damages, we will handle that ourselves. And I think that will also give me personal satisfaction to make sure that this is dealt in the right way. So I think we can agree to that and move to the next agenda.
We do appreciate your confidence and your candor at this point. Did you want to take lead?
I suppose in building off of this, in building off of the notion of copyright infringements and how we do deal with IP, it's a key issue of ours that once in the post-acquisition landscape, we would want to mitigate any competition risks between the newly acquired Baby Blue and Blue Entertainment as it continues on. And I think my council would be best placed to nut out how exactly that would work. But my understanding is it would be through two key provisions, those being a non-compete clause and a non-solicitation clause. And I will pass to you to unpack those in slightly more depth.
In terms of the non-compete clause, as you both know, we're both production and media companies evolving in essentially very similar markets. And the teen market is one that's quite niche in nature. It's quite important to us in terms of the non-compete that anyone from Baby Blue, once they join Red Media, once Baby Blue becomes part of Red Media, can't leave to establish a competing business, that be in comparison with that being with Blue Entertainment. There are obviously restrictions to what that applies to. So that's producing, distributing or broadcasting content that's of the same demographic, so that being teenagers, particularly in the educational realm as well, and also the geographical scope, so that being where we are actually operating. So that's the UK plus the current markets in which Baby Blue has expanded to. And additionally, the duration. At this point in time, we feel as though 12 years is sufficient. And what happens beyond then is beyond that provision. In terms of the non-solicitation, that is beyond if someone leaves our organisation to create that, and that Blue Entertainment can't actually solicit any of the employees that come with Baby Blue back to Blue Entertainment.
So for complete transparency, we are currently in an agreement with Discover Limited, which we are currently 3 years into a 5-year deal. And so we already have obligations, and they do have overlapping kind of fields of reach within kind of your definition. And that's obviously something that we can't back out of. That is, we're willing to kind of be flexible around that, but our hard line is that we cannot breach our existing contractual relations. And I hope that as businesswomen and lawyers, you can appreciate that from our point of view.
I think, would you mind unpacking what exactly that looks like? You did mention there was some overlap in terms of content.
Yes, so if I just find the specifics. So we have a radio show and podcast business which is through a partnership with Discover Limited and Blue Entertainment. And it's aimed at young people more broadly speaking. There's no particular demographic of teenagers and children, but of course that will encompass teenagers within it. There's, again, as I said, there's 2 years left in that deal, and we're definitely willing to negotiate non-competes and non-solicitation clauses around that, but we are not able to, leave that.
Would you mind just going over the content of that non-compete again? Sorry, just to make sure I've got that down correctly.
I think that was also in line with my next question as to what the radio and TV show looked like. It'd more so be as to what the 3Bs are currently doing in terms of their radio, TV news show every single day, as well as their podcast that's released 2 times a week. The content that's released on that, we are looking at no employee of Baby Blue can be taken to create a new product of that nature, or taken to the agreement that you have with Discover Limited to make that a very substantial competitor of the 3Bs.
Yeah, so can you just go through the
restrictions?
restrictions?
Apologies.
Sorry, yeah,
Yes.
just to make sure I've got those down correctly.
The first one being a restriction of activities. So that's the production, distribution or broadcasting of media that's of the same demographic. So that's specifically to teenagers, and that would be of the educational news / podcast realm. The second one being geographical scope. So that is the United Kingdom of A, plus the markets where Baby Blue has expanded to. So at the current point in time, that's USA, Canada, France and Germany. And the third one being a duration, that being of 12 years.
In terms of the duration, I think we had kind of a different idea. Just whilst my client writes these details down and mulls them over. We obviously hear your concerns about non-compete, and we had kind of preempted that this might be brought up. We were looking at something closer to like 5 years. Obviously, we appreciate that's quite different from your what you envision, so we're willing to kind of meet in the middle somewhere.
What's the range that you're looking at in that regard?
And well, obviously, our main priority is making sure that we're not breaching our existing relations. So that's
Certainly.
2 years.
Yes.
And then potentially we can look at a couple of years beyond that. So maybe instead of 5 years encompassing those 2 years, we could look at a grand total of 7 years, which is 5 years after our existing contract with Discover Limited is expired.
Can I clarify one more thing on those restrictions, please?
course.
I'm sorry if this is me having
No,
zero
do not
sleep and being
apologise.
very tired. So there seems to be 3 different restrictions,
Yes.
activities, geographical, and duration.
That's correct.
Those activities and geographical restrictions, do those interact with each other in that those activities that are restricted are only restricted within those geographical areas?
That is
Or-
correct.
Okay, thank you very much.
I did have one question in terms of the Discover Limited. What's the exact content being produced for the younger audience, as you say?
It just focuses on podcasts, and
Right. I think the key thing in terms of hearing about this relation to Discover Limited, and we do really appreciate your transparency in this regard, is it would create quite a challenging environment for us to launch our newly acquired business. And it would, I suppose, just add an additional layer of challenge in terms of establishing the niche that we are intending to establish, that being the educational, teenage-focused realm in which we hope the 3Bs to thrive. And with that in mind, I suppose, would you be more so amenable to extending that non-compete in a way to allow us a better, more confident foundation to respond to the issues with moving into the next 2 years, that we will have that added competition, but at least the peace of mind to know that a non-compete will extend a little bit longer than that 7 years you're interested in, perhaps towards the 10-year mark?
I think there was another consideration of that Discover Limited agreement as to whether you wouldn't continue with that beyond the 2 additional years that are
Yes.
currently in play. Is that correct?
yes, I mean, as we said before, we're looking at changing kind of the direction that our
Okay.
business is heading into. So we're not looking to compete with you at all anyway. So it's not a particular sacrifice. I mean, obviously, I'm only counsel, so this remains with my client, but I think there's a reasonable suggestion that you would need the comfort to kind of launch this business.
If I can just jump in from a client point of view. So I think we're aligned on the fact that I want Baby Blue to succeed. So in the launch of Baby Blue, absolutely, we are happy to have a non-compete clause to ensure that Baby Blue succeeds from there on in. For me, having been in the entertainment industry for so long and media industry for so long, we both know how quickly media trends change. So while we're pivoting today, I'd be very hesitant to enter an agreement longer than 8 years in terms of restrictions on activities and geographical restrictions, just because even though we don't have any plans for that today, and I want Baby Blue to succeed, I can't read into the future in those 8 years. So I think that might be my hesitancy there, maybe why I was slightly quiet during that period, just thinking of our plans into the future. So perhaps we can discuss a shorter term than that. We're happy to discuss a more strict non-compete in those first few years. Absolutely, for the 2 years we've got outstanding with Discover Limited. And beyond there, we look at a few more years. But again, I'd be hesitant to really have such a wide scope of restrictions.
I think we can appreciate the 8-year term. And I did want to clarify in terms of the non-compete clause, it means not taking any of the employees that come with Baby Blue and starting a new entity or a new project or a new media output which competes with that of that Bluebird offers. That is what the non-compete refers to. It's a competition clause in that respect. And the non-solicitation is soliciting any of the employees in order to make that happen, or to solicit the employees during that non-compete period. That's what that is largely in reference to. However, going back to your term of 8 years, that is something we can be amenable to.
Okay, well, I think that is agreeable. Again, I want Baby Blue to succeed. And listening to those terms, I think we're understanding each other quite well there.
Yes.
In terms of what we both want in the future. I don't think that conflicts with our future business plans. And I think that will help Baby Blue to really succeed at your company and help you guys nurture Baby Blue.
We know that the nurturing of Baby Blue is obviously the utmost importance for you. And so with that extra time, and in noting the outstanding 2 years you do have with Discover, we do believe that that'll put us in a more competitive position, which will only benefit the 3Bs and Baby Blue that you have set up over many years very successfully. I think in reaching that consensus, we can move forward. I do believe in our overarching questions, we reached a consensus with respect to the media offerings of Baby Blue post-acquisition, that being that we would be open to exploring, in addition to the podcast and the news, that additional comedy show, subject to making some changes so that it would align more broadly with our ethos. So I think we can move now to agenda point 5A3, that being Baby Blue's contracts with third parties. And I do note you mentioned the Discover Limited, I apologise, contract, but there are some others that we would like to flesh out in more detail.
Sure.
Of course, I think that largely refers to the merchandising contracts that Baby Blue has with the UK retailers, as well as the leasing equipment with UTV Limited. As you have mentioned, and as we really greatly appreciate, we do want Baby Blue to succeed moving forward. And we feel as though making that transition as smooth as possible, including with the suppliers and with the current licensing agreements in place, that can actually happen. We're wanting to understand if there are any specific terms of those agreements that wouldn't allow for a change in control or anything of that nature that we should be aware of.
Yes, so obviously the merchandising companies, they provide quite a lot of merchandise for us, like a real breadth of our expertise. There is a change of control provision, which would allow them to terminate the contracts. And obviously we can assume that will be of some concern to you. However, we are very comfortable with our relationship with the manufacturer, given the fact that they manufacture quite a vast variety of our products and have been doing so for quite some time. So we are quite confident that we will be able to achieve an agreement on the change of control.
I am happy to, on behalf of this agreement today, go to the retailers that I've known for years, so I've known them quite well, and I'm really confident that they'll give a waiver towards that. I'll do the whole pitch about Baby Blue going into the future, growing up, and going on and succeeding at your company. Again, that's because we believe in Baby Blue and because we believe in Red Media as well. So in terms of those provisions, just to succinctly point out, I think the concerns you might have, there are two contracts that we have that have that have change of control provisions. One is with our retailers, which handle merchandising, and one is with the 3Bs themselves. They have a change of control provision as well.
Right.
We've already addressed the main point that they had when we were speaking to them about this potential deal today, where they said the only real way they see themselves terminating that deal is if they couldn't continue with their comedy sketch. So we feel confident in that regard as well, that they will waive their right to termination. And again, using my personal relations with 3Bs and those retailers, I will go out personally and get those waivers to help us deal move forward.
Thank you very much for that. And those assurances are very helpful in helping us move forward. I would ask, is there a specific time period within which you would anticipate you could obtain these waivers?
Sure. So, I mean, we see the 3Bs around the office every day. So
wonderful.
We want to set up a meeting with them to discuss what's gone on today for their future. Again, saying things about what we're saying about their comedy show, moving forward, how you'd want to adapt their kind of outlook. And in that meeting, I'll discuss with them about waiving their change of control clause. So that could be within the next few days. And I can set up a meeting with our retailers. From our data, it seems like we provide merchandising through a range of retailers. So, I don't have any specifics in the data here. So I would estimate something like a month for me to get that waiver.
I think we'll probably look at, if this is within your proposed timescales as well, is to try and get this resolved or at least discussed in more detail by the time we next meet.
Certainly.
At the same time, we would really appreciate it if you could try and have maybe a more specific kind of understanding of what you might do with the comedy sketch. Just so, because obviously you have to understand that the 3Bs, we have to persuade them whether they want to move with you, and we don't want that to halt this negotiation any further than it needs to be.
The 3Bs ultimately are the crux of why we're here today. We absolutely see great value in what they offer, and so we definitely do want to discuss that more. I think that we can certainly establish some sort of a meeting with the 3Bs after your meeting with them and bring in our creative directors and see what exactly their show looks like and how it can align with our ethos. So we're very happy to proceed on on that basis. I believe there was just one other aspect of your contracts that we received information on.
And just the one that I mentioned earlier, you had only touched on that the merchandising agreement was the one that had the waiver. The leasing agreement of the equipment with UTV Limited, can you confirm if that one had required a waiver as well?
I'm afraid I don't recognise any mention of UTV Limited. Perhaps we could take a caucus and we can look through our information there, but
It doesn't seem familiar to me as well.
That is something we can come back to our knowledge. It was a leasing agreement for filming equipment.
okay.
Perhaps that is something that when we come back for our next meeting, we can have a little bit more information there.
Sure, yeah, we can look into any leasing agreement with UTV. It's not something that I've heard of, and certainly not something I have on the facts today.
That's okay.
But considering we're having another meeting as well, rather than taking a caucus today,
No, I think that's
I think we'll just come back with that information later on.
Certainly. I believe then that we can move to BIV, that being the employee benefits post-acquisition. I note that you raised this in your earlier expression of interest. So would you like to lead in terms of what you're exactly looking for in this regard?
Sure, so, you know, our core value, if you like, as strong as yours is for knowledge is power, is looking after our employees. As we've grown our brand, we recognise that our employees are filmmakers, production makers, whatever role they have in the production chain, they're all integral to creating our fantastic works of entertainment. So we provide our employees with a whole range of benefits, whether that's small things like a gym membership, also things like
Outstanding pension scheme.
yeah, there you go. I didn't want to say it and toot my own horn, but yeah, we do contribute to pensions above the statutory.
And what rate is that at?
I'm afraid I don't have the data for that, but perhaps at our next meeting I can bring more specifics there. So that's something we really like to ensure is continued, and also moving forward with Baby Blue transferring hands. We'd like to make sure that there are very few redundancies, if any, from this transfer. The way we see it, Baby Blue is a successful company as it is. They're making great strides, has great potential as a team. We are very careful in our recruitment process, and we think that the team already has great synergy. So we'd be looking for an assurance from you guys today as to your intentions with Baby Blue and how many redundancies you'd be looking to make, if any.
I think this kind of links into your point about wanting to make sure that you can grow this business as quickly as possible and as authentically as possible. And that the business, of course, you'll understand there's more than just the name and the product. It's the people that make that and have spent a lot of their lives committed to our company. So we want to make sure that there's nothing that can get in the way of you having a smooth transition and being able to fully benefit from what we can provide in this transaction.
I suppose in response to that, we definitely appreciate all that you've laid out in terms of the high level of care and nurturing once again you do provide to your employees. I suppose what we're looking and committing to doing is, again, at a subsequent meeting, looking at the exact specifics of what it is that you do provide to your employees, comparing it to ours and seeing whether we can find something in the middle that is financially viable on our end. At this stage, we do provide the standard what's the word? What was the word we used? The standard pension scheme rate. And that is essentially due to the way in which our company is structured. I understand that you would be wanting potentially above that. And a creative way that we could go about doing this is a phased cultural integration into what the way in which our company, Red Media, is currently set up, so that your employees that are coming over feel comfortable and can integrate over time into the way in which we operate.
I think to that point as well, on that culture note, with reference to the benefits, how much of the benefits are actually used by the employees? I understand it's all good and well if they're there and available for use, but how much of those benefits are used, such as the gym membership?
So we didn't have the data specifically on its usage, but we're drawing the reasonable assumption that our company is known for our impressive employment history and welfare. So we believe that these benefits must be used widely across the board, so much so that they're known throughout the entertainment industry. so that our brand image has developed in the way that it has.
I can just jump in, maybe with some more specifics in that. Obviously, we don't have any specific numbers to provide to you in terms of, you know,
That's
how many people
okay.
go to the gym. But we do have an exceptional rate of retention for our employees. Our business is so successful because the people that started it are still here. And that's what makes it so integral to us, that we keep those benefits. And I really appreciate your, you know, your cultural concerns and having a sort of slow integration. But we wouldn't want to see a long-term kind of, you know, loss of our employees' rights. That's something that's very important to us, is that we don't have any reputational implications that could come from, you know, our employees feeling that we have sold them short for, you know, the sake of money or whatever. We really value them, and also the financial implications that can come from any negative press.
I think on that note, we have essentially gone through the broad scale of issues here, and it might be suitable to take a caucus now, assess that, and see what we can look forward in terms of a holistic assessment.
Sure.
Noting it's not yet 10 minutes.
Go about 10, yeah.
Yes. So we propose, do we exit? How long? It's 5 minutes.
I think we need to just, yeah, I think we might be still very,
Here on the bottom against. But they were going to come back to with reasons.
waiver.
They need to come to us with information. I would stop it for them, like, for them. But we can- if we want to do something,
Yeah.
with that information. And I'm happy with you. I'm happy with you. Please. So
Thank you very much for allowing us to take that break. I think that allowed us to confer and assess holistically what we're looking at. I believe my council will run through essentially what we're looking for in terms of an initial offer and what that might look like, and also touching on your concerns that you raised with respect to culture and redundancies.
I think briefly at the beginning, you mentioned that the amount that you were coming in on was $38 million. If we could just have a quick understanding of what your absolute minimum was coming into this negotiation.
I don't think that we'd be willing to put an absolute minimum. I think we'd rather hear your offer before
At
we.
the start, we both said we're looking for, a value-driven conversation here. We think 38 million is a fair assessment based on the future investments we want to make in series, as well as the investments into our company.
In full transparency, we do have shareholders and stakeholders that are quite important to us. And coming in, our instruction was to come in at $17 million, which is a large gap in between where we are here today. As you have noted, we have had quite a productive conversation, and we do have capacity to move upwards from that figure. At this point in time, we do intend, and as you mentioned, there is an expectation of redundancies. A mass redundancy is not what we are after. There are only a few key positions that we feel as though would be an overload in terms of what we can actually retain for Bluebird, or what we see that progression looks like in the future. And we did want to disclose that to you in full transparency.
Any details?
We don't, but we can come back to you at the next negotiation with an exact figure.
Okay, thank you.
I understand that, merging two businesses, you might end up with two different roles. So as
And-
long as that you can provide us with an assurance that there'll be no mass redundancies.
No mass
And we'll
redundancies.
revisit the pensions at a later date.
Absolutely, and we can also look at that tiered system in making that cultural integration over time. But in terms of a range there, as I said, we did come in initially with far lower than what you initially proposed. So we would be interested in terms of the compromise you're willing to engage in today, moving down from that 38 million, say in between around the 25 million mark.
Well, we were just tallying up the things that we've agreed to during this negotiation today. To run through them, we see that the 3 Bs have been secured with the comedy show, but we see that as quite integral to your keenness to keep 3 Bs on as well. We've agreed to an 8-year term for a non-compete clause and a non-solicitation clause. We've agreed to indemnify you against the settlement regarding the YouTubers' claims. And I will personally source waivers and pitch to the relevant people the future of Baby Blue. So regarding that, we appreciate your commitment to no mass redundancies. Obviously, that's not quite what we are looking for today in terms of protecting our employees. And there's more to be said on that as well.
I do appreciate, and we want to clarify, it's not mass employees or a lot of employees. There are a handful of positions that are going in respect to that. But as you mentioned, it was just the natural shift between an acquisition between two organisations and what exactly that looks like. As mentioned, we truly appreciate the value that is placed on employees through Baby Blue. And my client wouldn't be here today if that weren't the case. And they truly see a vision for what has been created by the employees. And we do feel as though with that figure of around $28 million, keeping the benefits as close as they are as possible and keeping as many of the people on, whilst really promoting the positive push of Baby Blue, we do feel as though that is a fair assessment.
Look, I think a lot of it will depend on what we discuss at our next negotiation. As we say, employees are core to our business. So the benefits you can give our employees will greatly shape the amount we can give you.
I think also
looking at what we've agreed so far today, we believe we've made quite a few concessions. So we wouldn't be looking to move that far from £38 million at this time until further discussions are taken at the next meeting. So far, we'd be comfortable at looking at something more like £35 million based on our predictions from having a non-compete clause and non-solicitation clause for 8 years.
However, we appreciate your shareholders and how important they are. And I think one of our primary concerns is the timescales of this sort of payment. We mentioned that at the start, so I'd like to circle back to that before we take anything back to.
Certainly, I think if it's on the higher end, that's where we would require more communication with our board, and there would be a lengthy approval process. Engaging with finances, engaging with banks, working out all of those arrangements would take a longer period. If it was on the lesser side of things in terms of the monetary amount, it would be a more straightforward process. I would like to note that in terms of concessions, we do still have this underlying issue of responding to the copyright infringement claims, and we do know that you've stated that you firmly believe that there's no basis to that, but as it is an area of uncertainty to us, and it's causing some degree of reputational and potential legal issues at this time. There is still a large amount of risk here and a question mark, I suppose, in that space until it is resolved.
And I appreciate that our
ask- sorry.
indemnity wouldn't have covered that whole worry for you. And again, we're here to strike a deal today. We really think that Baby Blue would be very successful with you both.
Could I ask, I'm sorry to interrupt,
Okay.
but just in the interest of time, if that 28 million figure that you provided, would that be with sort of immediate payment, or would that be with a longer?
So there'd be about $17 million that could be immediate, and the rest would be subject to the board approval process, which is
2
lengthier, 2 weeks process.
We'd be interested to take that back to our board,
Okay.
and then we can't agree anything now
Mhm.
because that's significantly lower than what we looked at.
Mhm.
But
Can you
thank
just
you for
state
the
those numbers once
transparency.
again, sorry.
17 million approximately is where we're sitting at in terms of upfront, and then we have that other approval process relating to anything that exceeds that with our board.
Okay.
And the figure that we were presenting was $25 million. But as noted, we do have a future negotiation to have into play, and those are the figures that we are currently sitting at.
I thought the figure you were just discussing then was 28 million.
That's
So-
what I heard. I'm sorry if we
Yeah.
miss.
Apologies, it was 25.
Okay, thank you. We'll bring that back.
As noted, we do appreciate the conversation that we have had today, but we do look forward to the information brought to the next negotiation to see how we can progress moving forward.
We look forward to the next.
Thank you.
Thank you.
Thank
Have a lovely sit back.
Thank you.
We can all begin with the question and answer round.
Can we ask him to wait to stay?
Okay.
Yeah.
And then- Thank you. Can you just reflect on the first 10 minutes of that meeting? Tell me if you think you should have done anything different.
I mean, I think from our perspective, obviously we're the sellers and we were interested to hear what they had to say. So I think they did take a bit more of an aggressive approach, but what we were looking for is to get the best offer out of them rather than to kind of be aggressive ourselves. We were looking to, have that partnership and to sell. So maybe we could have, maybe taken the lead on a couple of points, but I think I was quite glad that we got out of them what
I
they were
think
trying to
when
achieve.
we thought about our position in the negotiation today, we recognise that a lot of it will be addressing their concerns rather than us asking them questions about their company. Our main question to them was, what do you intend to do with Baby Blue? And we were satisfied with that answer. I think we made concessions in areas where I don't believe we compromised any of our values. And I think we made considerable concessions, but towards the end there, I think that the ultimate value we could reach in this deal would have been in around £30 million.
Okay, and you were very quick to mention the 38 million figure. What if they came up with 45 million? But you mentioned all the thinking you had mentioned.
Sure, so we wanted to mention 38 from the start, just to set an anchor, just to set that window of negotiation just below there. Of course, if they had a higher figure, we then have to reevaluate. But we thought that based on the data that we had and our expectations on what they would pitch, we were comfortable taking that slight risk and leading with that anchor at the start. And I think that paid off with the negotiations we had at the end.
I think we kind of anticipated that the 38 million figure was already above what we had valued the business at. So we were quite confident that that they wouldn't have bid higher than that. We were quite aware that that would be an anchor point rather than a minimum.
In the first 7 minutes, I think they asked the question around, are you speaking with someone else? You may say, not speaking to anybody else, the first person.
Yeah.
Do you not think that you shouldn't have done that because actually created some competitive tension for them? Because they're more desirous. Or what was the thinking behind mentioning that?
Yeah, so I did recognise an opportunity there to create some competitive tension. But I think based on the demeanour we entered that negotiation, that more than anything, trust and honesty and transparency was key to this deal. Kind of trying to take on the role of Darren as well. I see him as a character who takes trust and integrity as very important values. So I wouldn't want to create any conspiracy about who we're seeing, and instead try to frame that as a real benefit of, we're here with you today and only you so far, as a sign of respect for the culture you have at your company.
I've got some more.
What's the interest you think of Baby Blue and your company? You were not able to protect anyone.
I think we didn't get the protections on employment that we wanted today. So it was really stressed in our briefing that we take care of our employees. And even though they suggested the creative solution at the end of a phased, I don't know, I can't remember what they called it.
Phased cultural integration.
Phased cultural integration.
Yeah.
I'm not sure that quite protected our employees to the extent that we would have wanted based on the information given
What
to
do
us.
you think that meant? Actually? Because I wasn't sure what that.
We weren't quite sure either. In the caucus, that's what we were discussing.
From my interpretation of it, it would be that they would acquire our employees with the existing benefits and they would slowly kind of align it with theirs. And I personally agree with Alex that it didn't look like it protected the interest of our employees at all. It looked like it would end up in 10 years' time, or even less than that, with them having the statutory minimum. And that's why we were very reluctant to actually agree to it.
We weren't sure whether that meant that the employees that we're sending off with Baby Blue would have their benefits phased out, or it meant that any new employees to Baby Blue wouldn't have those benefits. So that's why we were keen not to make that agreement today and to kind of kick that down the road to the next negotiation. And because of the time left in the negotiation at the time, we didn't have time to address that today. But that would be the main point that I think we didn't quite address today.
What were you most pleased with?
I think I was most pleased with the demeanour and tone we managed to strike today in the deal. I think that I was pleased with the concessions that we made. I think were calculated based on what we thought we'd get in return. Do you have anything?
Yeah, I think from my understanding of the brief, it seemed more like we wanted a deal than not to make a deal. And I think that from our perspective, it was to not be difficult. Obviously, they had a lot of questions, a lot of concerns that could have made this a very technical, very hostile agreement. And ultimately, what we care about is sending our company to somebody who will care about it too. And so we were trying to build that relationship and get a feel for the kind of people they would be, what they wanted to get out of that relationship. And I think that we did that. When we didn't commit to anything that would be outlandishly against our values. Anything that was kind of any concern, we're going to circle back to. But we did at least kind of understand an open negotiation with people that could be trustworthy.
And the main point we identified was that there's lots of opportunities for our business at the moment with WebVids, and there is a license for, I think, a werewolf series that we wanted to acquire quite quickly. And those opportunities were time sensitive. So more than anything, we wanted to come to a deal today within our price range so that we could move forward on those ventures. And by the end of the negotiations today, we already have them within our price range where that was possible. And I believe would have gone higher had we had more time.
Yeah, in terms of the pricing, we were expecting a bare minimum of 25 just to fund our sort of alternative ventures, I suppose. And we didn't even have to propose that to them. That's what they came up with themselves. So we believe that we would have been able to get them to go higher than that. I think that's quite positive.
Which I think was one of the benefits of setting a 38 million anchor at the start.
And being so friendly as well.
And you obviously were very time limited and sleep deprived and all those other things. So I think you rightly came to the conclusion that you weren't going to get everything done today. You achieved an awful lot in the 60 minutes, but what were the bits that you felt you underplayed or left too much to be done at the next?
Employment, just because of how important it is to my company that employment is addressed. Employees are supposed to be the core of our company. And I think one of our regrets from today is letting them take control of the agenda from the very start. If we had control of that agenda, we would have put employees at the forefront, and actually we let that go to the wayside until the end of the negotiation. So I'm glad that we didn't agree to anything today, and that we'll be able to revisit it further negotiation. But in terms of what I think we missed out on today, it was really emphasising the importance of employment in these negotiations.
But again, letting them kind of take control of that agenda was a calculated risk in terms of, nothing that they had on there was completely against what we thought, and our priorities were sort of addressed, at least to some extent. We thought that setting a friendly tone and being able to look at things more holistically, to come back to it, perhaps a little bit of a rush price at the end, was more beneficial than trying to assert dominance where we're trying to actually hear them out and get the best offer from them. Yeah, I think that's
If you imagine that next meeting, if you left today's meeting thinking that you needed to do more on the employment side, what do you feel you had left to trade to achieve that?
I think that, sorry to jump in,
No, please.
but we didn't really hammer home just how integral that comedy sketch was, and for the 3Bs, and so potentially we could have kind of leveraged the fact that they might be reluctant, because obviously another thing that we had to come back to was their structure to do with the comedy sketch, and whether that would be incorporated in the way that the 3Bs would agree to. And so we could have leveraged potentially the 3Bs to kind of really hammer home just how much we need this employment, because they wouldn't get the crux of their investment in the 3Bs if we didn't get our employment.
For me, I take the advice, actually. We made a lot of concessions today that perhaps wouldn't be at the forefront of their minds next meeting. That's why I really wanted to underpin all the concessions we've made today at the end of today's meeting. And I would, going into the next meeting, remind them of all those concessions again. But I do think you're right that then carries less weight than if we had negotiated them on the day. Of course, that's just one of the compromises we have to make in an hour to negotiate.
I think that's probably right, because the way I look at it, the only 2 points that are open are highlight supplies, and on the employment front, as we're very clear, the pensions go, other things we can talk about. So actually, if you were to go into a next meeting, basically left the market trade. We've given up on the indemnity, given up on the change of control, and hopefully we come back to the second. Basically left from the next.
I think that advice is important.
So just coming to the indemnity. You sort of very quickly agreed to an indemnity. You're open to accepting exposure for your side. You mentioned about needs to be specific. You mentioned needs to be general. Do you know what the agreement was? But I wasn't clear whether there's general indemnity or specific indemnity.
Well, from what we tried to specify at the end, it should be limited to any litigation that arises directly from the settlement offer that we would make, or from this specific claim that's been proposed. We wouldn't want sort of any general litigation. Again, we probably should have circled back to that if we had more time. I was quick to kind of accept an indemnity on that particular settlement because from our perspective there was no risk, so it was not particularly a loss, and we wanted to start off with that friendly environment again to show that we're willing to work with them.
There wasn't any risk.
If
you think that's a frivolous claim, why then not accessing indemnity? You should have said that to them. Look, it's really frivolous claim, and you made the point, which is so generic, and that in itself is indicative of it. You can decide on the repetition.
I think from my perspective at least, they got the security they needed, and we didn't lose anything. I appreciate that we could have lost something if it had amounted to a claim, but by offering an indemnity, at least the way I understood it was that it's a piece of paper that says that we agree to kind of help them, but that favour is never going to get called in. So they get the security without us actually ever losing anything that we feel is a real risk.
I think if tomorrow there's a claim from the third party, then you will be paying that more of that loss, and that obviously is more reputation on much broader.
I think from my perspective,
Yeah,
I think from my perspective, I would have liked to be more forceful with that indemnity. my gut reaction was to fight it and say, this is a frivolous claim. You're asking us to indemnify against something that two YouTubers have said online.
Yeah.
But I noted at that point that we're already at 30 minutes into the negotiation.
Yeah.
And we still haven't touched on price, and we still haven't touched on employment. And I think some other issues as well. So I think there's a calculated risk on our part, where I do think there is some risk in what we promised. But actually just to keep the negotiations moving forward, given the fact that as Darren kind of was confident that these claims have no basis.
Yeah, I think just to, sorry, I kind of maybe strengthen what I was trying to say, and like that was that there is of course a financial element of risk, but it's what our client kind of perceived as a real risk rather than just a risk that's out there in the world, and we didn't perceive, or from our briefing, it wasn't a real risk that we were concerned about, and therefore, although it is, you know, practically a risk, the reality for our client was that it's something he was willing to accept in return for moving forward with the negotiations.
So you're driven basically by the speed of the closure. That's what I take.
Yeah, on the indemnity, yeah.
And that is probably the reason you gave away the price. Did
Yeah.
you think about it? And what do you see the weakness for the other party? Did you feel any weakness that the other party exhibited during your negotiation?
So I think this was a point I think are open to admit we struggled on last night at 4 a.m. or this morning. You know, we saw the negotiation plan today as quite defensive. We're looking at what are their weaknesses as well that we can lean on. I think one of the weaknesses we didn't get to lean on is the fact that they're publicly owned. So, no, I'm thinking like Elon Musk. What if they have an active investor that comes into that company and says, actually, we don't like what the 3Bs are doing? And that's something I'd want to press on in the next negotiation as well. I think that was probably their biggest weakness. We identified some other ones as well. But mainly we thought that we could play this in a way where we can make calculated concessions and get a good price from those concessions, which we can use in our own investments to create much more profit in the future.
You may truly care about the company that you're selling, for which they're paying full value, right? Or what the value might be. If I'm the buyer, I'm paying you full value, and then you're trying to impose a lot of restrictions on how I have the wrong. Why would I accept or agree to page? So I understand the employment form that's really important. But don't you think it's difficult for them, because they have paid full value, for them to be biased for value around the company?
Sure, and I see the point. I think my response to that would be along the lines of the value of Baby Blue, in terms of its specific catering to Red Media's needs, especially where Red Media is looking to expand into the teenage demographic, and we've got an oven-baked media company ready to latch onto their existing conglomerate and instantly diversify their portfolio. So I wouldn't necessarily, it's just a case of buyer, seller, and we're imposing restrictions on them. I think that actually from today, what we're looking at is a win-win situation where we'll have the money to pivot our own business model, to invest in various other series, and they in return will get our Baby Blue, which will help them diversify their content in the way that they desire.
I also think in terms of restrictions, if you view it sort of slightly differently, yes, we're imposing restrictions on them, but actually there's nothing that we're adding that benefits us. It's all to benefit that kind of them. We're selling the business as it is, and our restrictions are basically aimed at keeping it as it is, and that is a successful business that we've built. So by imposing those employment restrictions and everything like that, that keeps it in the efficient kind of effective machine that it's been grown to be. And so that's the way that I would like to pose it to them, is how it's benefiting them rather than us.
Yes, so can I just move quickly to move quickly to change of control and third party. So you're very passionate about your relationship. But don't you think you actually underwrote change of control to that? And isn't it the case tomorrow if the third party will come around and say no, then it will land trouble? Because it wouldn't have happened for the contract.
I think definitely out of the topics we discussed today, I know it's integrity was at the forefront of everything we wanted to talk about today, based on the pitch we had. But I think that is tactically an area that we left quite vague. We didn't agree to, our red line was we didn't want to agree to any commitment that they would say yes, only that I would go out and pitch to those people who I have good relations with, the successful story of Baby Blue, which would then help this deal go through and again help foster the win-win that we're looking to create today.
And again, you pointed out that we had kind of two things that were left untouched, but we talked about the three Bs, but we never actually kind of provided them with any form of written confirmation that the three Bs would join. So again, we could come back and say, well, the three Bs require this, and therefore that it allows us to leverage a bit more in the next negotiation.
And I just also, as I said, wanted to ask the same question in a different way, right? So I must compliment you, showed the passion and the emotions as a promoter, right? That you are attached to the company, you know the business habit, right? But of course, you also thought that you gave away too many things, right? But I have this question for the council, right? Were you comfortable with this kind of a giving away so quickly discussion, while I think the other party was not giving you what you wanted?
I think there was a slight bit of discomfort that we talked about a bit in the break, where we did feel that we were giving away quite a lot. But again, from my perspective as counsel, obviously it's the client's call, and I can only advise him on what I think is a risk, and if that's a risk he's willing to accept, then so be it. So for example, with the YouTube point, again, it's a risk, a financial risk that our client didn't feel was powerful enough to not, give away and concede in trade for such a positive relationship or an efficient negotiation. So I'm comfortable with it if my client's comfortable with it. That's my role.
Okay.
And on a competition level, we had written down everything that was said today in our plan as our line. So we didn't give away anything more than we're expecting.
They just got to say it first.
Well done.
Thank you very much. Thank you for your time today.
That was great.
Yeah, that was good.
Thank you.
Yes, so do you mind?
Hello.
Hello. Why don't I make a start? That's okay. I asked the other team the same question. I'll ask you the same question. So how did you think the first 10 minutes of the meeting?
I think that we had control in the first 10 minutes by presenting the agenda and listing out the questions that we wanted to assess. We also were very active in our icebreakers and creating that positive working atmosphere from the get-go. I think we did get bogged down in terms of the agenda item and where the holistic assessment of the sale price would sit. That was a part of our strategy that we wanted it to be at the end. It did ultimately lead to some time delay and rush discussions here and there, but I think that's ultimately inevitable in the 60 minutes.
I think the first 10 minutes were promising in terms of there were common interests that we could work through, and there were questions that had answers to them as well, which is a good point to move off. But I think there was a good working environment that did continue throughout the course of the negotiation that did stem from the early stages of negotiation.
If you were to reflect overall or not, then do you think that you sort of got everything that you want?
We got a lot of what we wanted. Essentially, in going into this meeting for our client, it was largely an investigative process. As the party acquiring the other side, we need to scope out what exactly is involved. There were some key unknowns going in, for example, the copyright infringement, the ongoing contracts with retailers. And we also discovered that there was a Discover Limited contract as well. There were some unknowns there. We didn't really have an opening figure either. That was presented in the opening 10 minutes, I suppose, again, which we noted. We also noted in that whole process the fact that the other side indicated that they are exploring other options, and it still is a potential for them to retain Baby Blue, but that we are their priority and what they believe to be their best option. And from that point onwards, we knew that we could be more aggressive, noting that we were, I suppose, at the top of their list. But returning to your question in terms of what we do the same and what we do differently, is there anything else you want to add to that?
I think effectively, in a first instance, as you did mention in the due diligence process, it's assessing that whether we are putting tens of millions of dollars forward, there is going to be significant returns. Our liabilities aren't going to be extortionate. There isn't going to be the potential of competition that's going to emanate from this entity or from an agreement taking place. That was really important to us that before a figure was put forward or before we had an agreement on a specific figure. Again, noting that this was preliminary discussions. Ultimately, we had assurances in terms of the liability, in terms of the compete clauses, in terms of the agreements carrying over, and then also understanding that the three sisters or the three Taylor sisters had that non-compete clause, that there was scope to actually work out as well. Ultimately, coming in, there were the three pieces of media that were at the centre of this entity, being the news outlet, being the podcast, as well as the TV comedy show. And just from the point of Red Media, there's an element of really focusing on knowledge and education. And coming into this negotiation, we were of the position that comedy show wasn't something that we really wanted to carry across. So if it were to carry across, that was something that we would be open to getting rid of. But when we realised that that was a concession that we needed to make, even though it wasn't outwardly said this is a concession that we're making, it was ultimately tiptoed around. That was something that we were prepared to do, noting that we received a few of the other things that we needed to even consider a figure.
What were you most pleased with?
What we're most pleased with, I think that there was an amicable working relationship when we actually did get to discuss everything on the agenda at a high level, with probably the exception of different payment timings. We did get to the very last minutes where the council for the other side said we will take back the figure of the around the 25 to 28. There was some confusion there due to a slip of the tongue. We'll take that back to the board on the basis that 17 million is paid immediately. Now, it does seem that there was some mutual agreement on that terms that could have been raised earlier. But I think if we sacrifice going through the detail of, for example, the non-competes, the competition issues, the copyright infringements, and dealing with issues of employment culture, if we sacrifice that detail, we wouldn't have been in an informed position to really provide that figure. So I think what we were pleased with is going into enough depth to put us in a position so that we had the agreed next steps, what other information we wanted to get to, in a way that, you know, we covered the field and had a good amount of detail for the time that was provided.
I think at a high level, our instructions coming into the negotiation were to scope out, noting that there is a gap in Red Media's teenage provisions, what that actually can look like and how we can get that across the board. We did have very stringent shareholders and people that have very particular impressions or experiences that they'd like to translate into how debt or equity or the gearing of the organisation is met. And they were considerations that we had to take on board, and that does extend to the liability. So I think making sure that the first figure that we put forward, because it's always easier to go a little bit higher, but it's never easier to bring down the first initial figure that you give forth. So I think making known that there was a figure that Mr. Purple, who is the shareholder on our organisation, might be a little bit happier, a little bit more compliant, and can get that across as quickly as possible. As we did note, they were really concerned about that initial figure and what that would look like. And that $17 million won't change irrespective of how long it takes to get him on board. So I think that was a consideration of making sure in the back of our minds, he was going to be our biggest hurdle in moving forward and having a little bit of complacency with him.
Is there anything you could have done differently?
I think potentially time management was our greatest weakness here, as we did mention at the beginning of the negotiation. An hour slips through your fingers, particularly where there are so many elements to get through, when there are quite a few legal and commercial issues to flesh out in a negotiation. I think as we intended to have 30 minutes to really push through everything and then have at least 25 minutes to have a really good discussion of what our position was. In the future, it might be best to take the break a little bit earlier. However, we needed all the information before we could have taken that break. So I think in terms of time management, it could have really helped us have a bit more of a closed or a sealed list of things to come back for the next negotiation.
Back into the news.
So that was so that we could discuss what we were willing to propose in terms of the employee benefits and the total amount. So we were willing to go around that, propose the 25 million, noting that it would be more within, as council mentioned, our stakeholders' interest for it to be lower, noting that we could come to around 25 million if there was some sort of a movement in terms of the employee benefits. And it was at that point, right towards the end, when we did have all that information, and that's why we took the break.
In the same vein, there was, and as I mentioned a little bit earlier, we came with very strict instructions from our client coming in, which meant that they were completely looking to reduce all the employee benefits. They had very strict requirements of the amount. They had the element of redundancy that we did disclose in full transparency, and we looked towards our notes at the end to confirm that what we were advising was correct, that it was a few positions. It wasn't until we had a full understanding of where we were sitting in terms of our mental scale. We have ultimately a table that we run off of our ideal position, our middle ground, our walkaway points, and just some creative solutions in the back of our mind, and just making sure that we were in a comfortable spot to return to our client for an initial meeting. And it wasn't until that point, and we knew that we had to concede on the benefits element, and we had to really bring that lower price up. And we just needed to have a quick conversation to look at how we can package that as best as possible, noting that concessions had been made both ways.
What do you think you agreed on the indemnity?
In the indemnity?
Yeah, what do you think? What was the agreement on this? There is an indemnity. What do you
Yes.
think?
In terms of the litigation, it was that they, should any issue arise prior to the acquisition of Red Media of Baby Blue, sorry, I get the names confused, of Baby Blue, that would be absolved from Red Media, and Blue Entertainment would take that on board. With specific reference to the litigation, they would look towards any settlement amount and pay that amount as well. And should that settlement or the terms of that contract be insufficient and the party still had the capacity to bring a case in the future of the same nature or similar nature towards the three tailors, and we would still be indemnified of that as well.
And do you think they understood that?
I think we tried to.
I think my council made it quite clear that even if this present issue was resolved, if something came up into the future, which was ultimately related to the way in which the company was managed under their guidance, then it would be within their realm to respond to. Now, we did move through that quite quickly, and we were of the opinion that that was the agreement there. But ultimately, perhaps we should have revisited some clarification there, but that was what we were looking at.
I thought the might have been a misalignment as to what they took away and what you. But perhaps.
There's a lot happening in that next meeting.
Yeah.
And what do you, and where do you think, I mean, the other question I have just on the indemnity, they really want to take control of the settlement goals, of the litigation goals there, isn't it? Ultimately, it's going to be your business. Are you comfortable giving them control of something which might have a reputation back?
So it was not really what we anticipated, that they would want to direct a large amount of discussions to the different options. And they seem quite keen on asserting that they do honour the value and the image of their brand, and they think potentially defending that in court would be better than a mere settlement. But there seemed to be, above all, flexibility from the other side to take into consideration our interests. There was no definitive at this stage, but I think what I did actually mean to notice when we were circling back was that in any decisions in the near future before and I suppose after the acquisition, that we do have input into the settlement arrangement. That's something that we missed due to time, but I think the broad spirit that was conveyed, although there was no concrete agreement, was that they did care about our impact, sorry, our input in terms of how any settlement or litigation would impact baby blue in the future. They do ultimately say that they care about baby blue. And so we would, on that basis, believe that there is that care and, I suppose, mutual cooperation in that vein.
And so moving to the change of control third party suppliers, again, what do you think you would read there?
The waiver that if there was the agreement to, apologies.
There was 3 different contracts. We were aware of 2 coming into it. The first, the filming equipment, which they didn't have information on, and we asked them to obtain that information. The second was in terms of
The UK retailers with the change of control, if there's any clause in there that would allow them to cease the contract. And he made it known that he would have the conversation with them to have them sign that waiver so that they wouldn't enact that clause, and that transition would go ahead and would flow with the baby blue acquisition.
When we asked them the same question, they agreed to
there was quite a confident assurance from the client that as they had a long-standing business relationship, that they could assure that within a short period they could obtain these waivers. Again, nothing was concrete, and we did plan to have another meeting after those internal meetings were had. So I suppose that would be a check-in opportunity.
I think there's a bit of
What that concrete thing be?
The drafting of terms.
What specifically?
with reference to what exactly, sorry?
He's giving you this confident assurance, you know, speaking from the heart, all the usual stuff, that he's going to go and sort it out for you. It sounds wonderful, but obviously it's meaningless until you write something down.
Yes, so
I just wonder, and you were talking about looking for something concrete, right? But what would that be?
I think there's the fact that he mentioned specifically that they anticipate the signing of a waiver from the three sisters within a few days, and then a conversation and the potential signing of a waiver from the merchandiser before the next meeting, so that if there were any issues to arise and they didn't intend on signing that waiver, then that conversation could be had then. I think there was an anticipation that a conversation would be had, whether there was any movement from the implementation of that clause, whether there was any potential for that waiver to be signed, and if we needed to be brought into that agreement as well. I think just a concrete understanding of, and if there were any exceptions to that way, to that clause, and what that would actually look like for us. I suppose at this point in time, it wasn't a key concern for them. There was an intention to see what could happen there, but as mentioned, that was something to be concretely discussed at the next meeting.
I think in addition to that, when we are in negotiations, I think a lot of the time one party is providing all of these assurances, which you can certainly critique and say that they are meaningless. And we could have continued to say, well, how exactly do you provide, do you suppose that you would do this? How can you actually assure this? But I think we made it clear that we wanted to discuss as many things as possible at a high level. And so we didn't see, for firstly, the purpose of working relationships, and B, just the time management of getting through everything, to press multiple times on how exactly you can assure this. We assumed that those would be attended to in the meetings, and we would check back in afterwards in terms of the status of the waivers, which would be the eventual concrete agreement.
We spoke quite a bit about non-solicitation and non-compete, right? But how important was for you to retain the promoters, the key promoters for
The three Taylor sisters, it was
because I
very,
didn't see anything about that.
in terms of,
Retaining them.
I think we did speak to it in the sense that I made it quite clear that the main thing we're looking for in this acquisition is the 3B's news and the podcast. The 3Bs stand for those three
That's
sisters.
the product.
And then there was also the conversation of if they had any intention to leave or move forward, or the potential conversation that they had that they wouldn't even consider moving over if there was any change or they had to stop making their shows. It's essentially the 3B sisters, and they are essentially the product in and of themselves. It wouldn't be, I suppose that was almost implied or presented in the questions that we were asking of if they had any intention to leave, what that would actually look like, and the actual signing of what was the clause? The change of control waiver, and the conversation that we had we were of the assumption that they were would have a conversation in that space, and also noting that they made it very clear, and it was made clear to us that they wouldn't even consider moving over if there was a removal of the comedy show. So we can aspire to the fact that they did have the intention to come along with the move of Baby Blue.
What do you use the phrase phased cultural integration? What does that mean?
Sure. So I think what we tried to do then, again, it was a rushed process. So we know that they have good employee benefits that a large corporation like us cannot necessarily match. We meet the statutory rate of 3%. So we didn't get into this in much detail, but essentially what it means, we would start with offering them more generous benefits to ease the transition, and over time gradually reduce that once they're more comfortable and I suppose acclimatized to
Would
the.
that not upset your current employee? Most people eventually will offer.
I think it was not necessarily raising the 3%, but looking at other benefits as well. It was discussed in very broad terms, and if there were benefits such as a gym membership, it would not be limited to these new people, but I suppose a more broad change to how we operate.
If I wasn't your, I can.
We would be extending to you as
So
well.
you would extend it to your entire company.
Well, we've identified that this acquisition is very favourable in terms of the gap that we do see. And if we look at the options presented to us, we did not have another option moving forward of how we could boost the teenage space in that sense. We could have done it purely internally, but I think that would have taken a lot more resources and costs than perhaps improving benefits across the scale for all of our employees.
One last question, and then. Coming back to the funds, you said very firm 70. Then very quickly, within 30 seconds.
It was in the sense that when we were coming into the negotiation, our instructions were, and what we can provide up front were 17. However, based on how the negotiation had gone and noting that they had come in on a figure of $38 million, which is more than double, we were willing to meet more in the lower end of the middle. So that was kind of within the higher end of our scope, but that was a jump we had made, taking into consideration the concessions there.
You think you've got 25? How are you going to bridge the gap between 25 and 35? Then,
So I
because
think
you clearly don't have such technical get finance, and you've got Mr. Sutherland back, so we can do that.
So I think that's why we noted the instructions initially were 17 million, and we can move to around the 25 million mark, and that's why we asked what is the lower end of the range that you're willing to accept. And then they dropped slightly to about 36 million. Then they asked again about how much the timeline of the payment, and we said that there could be $17 million up front, and then there would be the further board approval processes. And this was in the very last moments of the negotiation, but it was said by council that we could take that proposal back to the board. The idea of having $17 million upfront is a good, is essentially in their interests, and that was a more attractive arrangement there. So we thought that that was them moving down slightly. So it wouldn't necessarily be the 25 million and then the 38, because there was movement throughout and there was some leeway that we established towards the end.
And I think we also know never take the first figure or the second. So we also know that there is movement in respect to there, and they have things to take back to their board, information to bring back to us. So there's still movement in terms of what that financial remuneration actually means for the both of us, but we kind of held firm that the 25 million is on the higher end, and we do see that to be a favourable amount.
And an attempt to meet more in the middle.
If you were them, would you follow some of the strategy of putting the number out?
And say that's a great point, because it was quite funny that they were asking what's your minimum price, right? Usually it's the seller who asks that, right? What's your floor price or what's the range you are looking
I
at?
think sometimes,
Because otherwise you wouldn't give concessions, right? And so yeah, back to six.
if I was them, I would have proposed a higher, I'm assuming this is on the higher end of the figure or a high ball entirely. I would have done that if I was them. In terms of, could you repeat your?
Well, what's the benefit of doing? What was the, I mean, ideally, if you're selling a business, you want everybody to tell them their price, because they're doing the valuation, you tell them what the price. What was the benefit of them for the route if you were them to do that?
There can be a benefit. It's obviously was quite attacking from them in the sense that they would have led with the initial figure there. I think though we didn't really respond to it. And so we didn't necessarily give it a huge amount of power until the end, in which we took that break after having all of the facts and then came back with what we presented.
But I think in short, no. And I think that there was conversation to be had about what the expectations were of both parties before a figure was to be presented. And that was something that we did consider for both parties to do. They were quite persistent on that point, and we suggested you can put your price forward, but we have considerations to make before we can even consider what our price looks like.
And so in a similar way, in they obviously were very passion and if you were there, would you have followed that kind of sort of not very well?
I think that potentially concessions could have been withheld. There were things that we were getting seemed to be received quickly. In terms of the indemnity, we were absolutely just taking what they said as correct because that's what we could go with at the moment.
And I think we did enter the negotiation in good faith and did hone on about transparency, and that was something that was focused about. So I think that's a good faith element from us.
In terms of the indemnity though, they were very firm in their position that there was no base to the claim, etc., that they hand on their heart believe that this will go away in one way or another. So in terms of the indemnity, I do think they should have made those concessions because we rightly brought up that if you believe so confidently in it, an indemnity should not be an issue. So for the indemnity, I believe, yes, they should have made that concession at that time. Potentially, I would have, if I was them, tried to negotiate more in terms of the non-compete. We did highball them initially with that 12-year term, which we thought we needed to do. And I think we were very pleased that we did do that because we eventually made it at what we were willing to, which was that 8 figure. I also think they could have negotiated more in terms of the geographical scope. And they sought clarification on that a few more times because essentially we're operating mainly in the UK. The other side has more of an international lens and has established their market in, I think, 5 to 6 different locations, which we listed at the time. If I were them, I would have seen that as quite a problem that it's in many different jurisdictions now that this is operating. So I would have changed my approach there.
And I think one thing that we've noticed with other competitors that we've negotiated against, no one's typically agreed to complete indemnity up front. There's always been a cap on the amount that they'd be comfortable with, or they'd say, we anticipate it to be this amount, but we'd give you up to this, and not really accepting it all in one go. If we were on the other foot, I think I would take the approach of either a cap on what that would look like and say, well, we can see what that looks like when it comes to it. But I think we did really hone in on the fact that it was an indemnity that was applied to a fault or a breach that occurred when they were in control and should have been due diligence or something that they should have looked into at that time and kind of absolved ourselves from that because we haven't even acquired the company yet. This was the first initial stages. It wouldn't make sense for us to acquire that liability this early on, especially when we're going at a higher price than we would have liked to come in on.
So is there any major points which you did not achieve except for price?
I think there was one point that we were to discuss, and it does speak on the point that you spoke on earlier about if they were to leave and Red Media wanting to be reimbursed for some of the purchase price. That was something that we were hoping to get to, but again, with time management, it was a little bit difficult to get.
No, the price is fine.
Oh, no,
Apart
it was in terms of if they were to leave, then Red Media would want to be reimbursed for some of the purchase price from Blue Entertainment. That's something that we would have liked to have discussed a little bit more to see what that actually looked like. But I guess we first need to get a signature that they're actually coming across and coming abroad to us before we speak about what happens if they leave.
And I suppose what exactly the waiver looks like and the indemnity looks like, we would have liked to have that again, I suppose, in more detail. And if there was different interpretations, and that's obviously less productive. So reaching an agreement that we actually are both on the same sides in those two things is critical.
So just to extend that, is it a good idea to give them more time, given that you didn't have anything more to discuss? You got what you wanted.
I think we didn't really have confirmation that they were coming across, or we didn't have confirmation that a waiver was going to be signed. It was just that conversations were going to be happening, and there was an expectation that it was.
Pardon?
He assured you.
He assured us
You
that
didn't
we'd have.
ask him further questions.
No,
on
he
that.
assured us that he was going to speak to them and see what those terms look like, or see what the various terms. So I think to that point, in terms of timing, they did note that this was the first meeting that they were having. So in that sense, you could suggest that there is an aspect of urgency, because they may well come across better offers. But that being said, we were not in a position to get everything ironed out and agreed now. So I think that's where we stand in terms of
So
time.
what were the two issues that you think they really cared about? And what did you do to protect them?
I think inclusion of the comedy show, which our facts indicated we were not interested in, unless there were changes that were made so that it aligned with our ethos. And we applied an interest-based strategy in that approach because they indicated that that was a non-negotiable. And for us, we have a very well-built company with resources that we can, as we've suggested, set up a meeting with actually the 3 Taylor sisters and our creative directors and see what exactly it is that is in the comedy show for starters, because we didn't actually know and we couldn't have more specific details there, and then see how we can rework that and embed an educational lens that is ultimately at the forefront. That was one aspect. I think the other aspect was
The employees would be the second aspect. And in terms of, they made note, initially they said we want no redundancies, and then they said if there are, we want very few. And we went back and said, in terms of the redundancy point, we do expect there to be, but we do expect it to be minimal. We were clear on that point. In terms of making sure that what Bluebird, Baby Blue, was in terms of the crux of it and how it was presented in the ethos in that respect, we held clear that we do want to stick to that, and we do know that there was an educational bound that really flows through both of the ethoses of both of our companies. And the last one being the benefits, that was a point that we did make concessions on. We were willing and open to going to the 3% from the get-go and getting rid of all the other benefits. But we've considered a tiered approach and keeping it as consistently as possible for as long as we can, and then making that change. Unfortunately, in a negotiation, you can't get everything, but we try to make it as practical as possible.
Do you think they were convinced on your argument of redundancy?
that less so, I would say, than the comedy show.
Or did you have any agreement on that?
It was mentioned and there was no question. They asked how many, we don't know how many. We asked how many people were coming through or what they expect, and that was something to get back onto that point. I think it's just a matter of, we made it clear that it was a few, and they said, we just don't want it to be mass redundancies, and we said it's not. So that was our assurance in that respect. Yeah.
Right, okay, well done.
Thank you.
Let's go. One thing else. Just a space. I wonder if they think we should have started on the 17th. We could have just said, oh, but they.
Yeah.